Are you confident?
India Lordship.
You must be confident. Lawyer जो बोल दिया वो बोल दिया. You must say all these things with confidence.
Conclude your argument. Conclude your argument.
My co-counsel will
Yes.
continue with us.
Yes. Yeah. Continue.
Your Honor, now I would like to cite cases. Like first case is of Shafeen Jahan versus Ashokan KM. In justice case Swami versus Union of India, this court in a decision of 9 judges held that the ability to make decisions on matter close to one's life is an inviolable aspect of the human personality. The autonomy of the individual is the ability to make decisions on vital matters of concern to life. The intersection between one's mental integrity and privacy entitles the individual to freedom of thought, the freedom to believe in what is right, and the freedom of self-determination.
Counsel, first of all, point out how this judgment of this Puttu Swami case is applicable in your case.
Your Honor, it is mentioned in the case which I have referred of Shafeen Jahan versus.
I am simply putting a question to you, how this judgment is applicable in this case.
Your Honor, as it is written that in this case, the court held that the autonomy of the individual is the ability to make decisions on vital matters of concern.
Whereas allegations against you that you, along with your co-accused, along with the bottle of acid, virtually threatened that poor lady, dragged her in the vehicle, and you are saying that you are getting the benefit from this Puttu Swami's case.
You know, Akash's intention was not criminal, but it was rooted in the belief that Anita.
You are there along with the bottle of acid in your hand. You are saying you are not having the criminal intent.
Your Honor, he was being a consenting adult, as Anita was being a consenting adult.
Where is the consent? She said no.
Your Honor, the autonomy of her when she said under her parents' pressure. Yes, Your Honor, indeed, Your Honor. She had the autonomy to marry whom she wished. His attempts to pursue marriage despite parental opposition stemmed from his respect for Anita's personal liberty, not from an intent to harm.
Once that lady says no, how can you interpret those words in your favor?
Your Honor, it was that Anita was from initially not very clear about the disinterest, which was that she was telling.
She has shown the disinterest. Yes, she has every right to say so.
Indeed, Your Honor.
Yes.
But initially also when she told about her disinterest, she never mentioned that I don't want to marry you or anything else. She clearly said that if you want to marry me, you just go and tell to your parents.
That can't be interpreted as yes.
Just because of the initial distress.
Have you seen the picture Pink?
No, Your Honor.
Amitabh Bachchan wali? No means no.
Once she said no, means no.
Here there is no marital relation between Suresh, Akash and what's the name of lady? Anita. There is a separate issue. Even the wife, if say no, she can't be compelled. पत्नी भी नहीं, बाकी तो छोड़ो. लॉ ये कहता है नो मतलब नो. तो यहाँ उसने बिल्कुल सही कहा, no means no. And
ultimately, Your Honor, this does not clear us that he is liable under section 124, which is read by section 3, subsection 5.
Right. Main accused as absconded.
Your Honor,
you can't take disadvantage of this fact.
But Your Honor, there was
negative act, not positive act. He is not before the law.
Indeed, Your Honor, but there is no common intention. He was himself shocked when he threw acid on her. And because of the situation that arises there, that he panicked. And due to that reason and due to influence of Suresh, he decided to go and run away from there.
Even in the Virendra Kumar Ghosh, the person who was standing outside the post office, he was not knowing this fact. He was snatching the bag. The other accused, his co-accused, been shot at the postmaster. He was just standing outside. He was not present there. In spite of this fact, the Honorable Privy Council has convicted with the help of Section 34.
If there still was a permanent tension, he would have fled away along with Suresh while he was in his own house only after he committed, if he was really intentional with that.
That is your conduct. That is also a relevant fact. It's only relevant fact.
Whether the good conduct of the accused or no case against him can be benefited towards this Akash. Whether he can get the benefit of good behavior, good conduct, and no criminal history.
If I'm not very clear about this, but if proof regarding a particular conduct, whether it's good or bad, I'm not confirmed.
We are accepting this. He was of a good conduct. No offense is created before that.
Still doesn't exist.
Whether he will get some benefit, your client of that. कि सर मैंने तो आज पहली बार हुआ है मेरे साथ
पहली बार मर्डर किया
पहली बार की है मैंने ये गलती
मर्डर पे पहली बार मर्डर किया छोड़
हैं नहीं एविडेंस एक्ट है
भारतीय
साक्ष्य अधिनियम का सेक्शन हमें पढ़ने पड़ेंगे 53 54 क्या कहता है इंडियन एविडेंस एक्ट चलो आपसे
You're talking about bad character development. Is it that?
Good character and bad character of the accused.
Yes, it is like I think on section 48 and 49 of PS. If I'm not. But still, I'm not clear about that fact.
जब कोर्ट आपसे कुछ क्वेरी कर रहा है और wants something from your side, you must say yes. अपने क्लाइंट के बारे में बोल रहे हो कि नहीं ये नहीं ले सकता बेनिफिट कोर्ट को पढ़ना भी सीखो क्या बोला नहीं सर आप हम नहीं बेनिफिट लेना चाहते आप तो ये बोल रहे हो एंड देयर इज क्वेश्चंस लाइक दैट कि आप यस करेंगे उसके लिए ठीक है ना बैड कैरेक्टर इररिलेवेंट गुड कैरेक्टर रेलिवेंट इन क्रिमिनल लॉ ठीक है और सिविल लॉ में उल्टा है
Much obliged, Your Honor. Now, Your Honor, my co-counsel will deal this issue number 3 additional.
Yes.
कोई बात नहीं यू डन वेल इतने गोले मिसाइलें पड़ रही हैं आप सह रहे थे ये बड़ी बात है ओके ये कॉन्फिडेंस चाहिए बाकी तो केस तो चलते रहते हैं
कंटिन्यू
In procedural
Yes.
much of that. Honorable judges, in the hallowed halls of justice, where truth must prevail over suspicion. Akash stands before you, a young teacher, enshrined not by malice, but by the tempest of unacquitted love. His heart sought dialogue, not destruction. The Lordship, his trust in Suresh was shattered by betrayal. The Lordship, issue number 2 before this honorable court is that is Akash guilty under section 78 and 87? Read with section 3, subsection 5 of PNL. The Lordship, particularly, I would like to mention that there has been an error on the part of the state in this very particular matter. The particular charge of abduction was not made, not by the session court. They have not taken any cognizance of section 87 as well. Even the High Court acquitted, notably, under section 124.3. There has been no mention particularly of section 87 which relates to abduction. Lordship, if at the appellate stage in the Supreme Court, new charges without prior information may be introduced, it will lead to injustice with my client. So, Your Lordship, we challenge the very admissibility of this particular section. Further moving, Your Lordship, as far as the stalking is concerned, the Lordship, Section 78 demands specific intent to foster unwanted interaction through repeated contact or monitoring. The Lordship Akash, a science teacher, swayed by love's storm, contacted Anita not to harass but to plead for reconciliation. It is to be noted, Your Lordship, Anita said no, not clearly. She just stated that talk to my parent. Your Lordship, this clearly shows that she was under the pressure of her parents. Her conduct may be inferred from this very fact. Your Lordship, it is to be noted that the right to choose whom to marry and whom not to marry should not be done in any kind of pressure. It is a fundamental right to marry someone of your choice. Akash inferred that she is just following her parents' order and is under coercion. The Lordship Akash simply wanted Anita to accompany him to get married. As it is to be noted, Your Lordship, both are mentioned. Anita can marry Akash as per her individual choice. Your Lordship, there is absence of mens rea related to particularly
But
Stockholm.
at the relevant time, you were carrying the acid with you.
Indeed, Your Lordship, it is to be noted that there is a concept of who
हाँ हाँ बोलते रहो.
who actually committed the particular offense. Your Lordship, it is to be noted that it is Suresh who actually made up the plan. He actually created in the mind of Akash that you can do this particular thing. It is to be noted, Your Lordship, the responsibility of acid was not with Akash. It was with Suresh only. As far as acid thrown is concerned, Your Lordship, Suresh particularly threw the acid as stated by Anita in her statement also. It is to be noted, Your Lordship, hypothetically, if we speak that Akash was holding Anita while Suresh was throwing the acid upon her, it is to be noted, Your Lordship, if he had thrown acid upon her, Suresh, then Akash would have also got hurt if he was holding Anita at that particular time. But it is to be noted, Your Lordship, Akash suffered no harm at all. So how can the justification be made that he actually was holding Anita while the acid was being thrown on her, while Suresh threw acid, he was dragging her into the car. Further, Your Lordship, attempt in this very particular case, if Section 87 is taken up, Your Lordship, even the attempt, the completion was not there. The abduction did not got completed. She was not restrained from the particularly the control or the general supervision of her guardians. Is there. Your Lordship, he was not taken away from the unlawful custody as well. Your Lordship, the particular liability under Section 78 and 87 does not stand in this particular case. I would like to refer the case of A. Venkatesh Ballu versus State of Andhra Pradesh. That mens rea is essential for stalking. Impulsive or emotional contact does not suffice stalking. The Lordship Akash is hurt, clouded by passion. Sound connection, not coercion. Your Lordship, a teacher's plea for love is not the predator's pursuit of love. Further moving, Your Lordship, no harm conditions undermine mens rea. It is to be noted, Your Lordship, Akash's explicit condition that no harm come to Anita proves his intent to avoid distress. In state of Maharashtra versus Mayor Hans George, the court emphasized that a defendant should not be found guilty unless he has a guilty mind. It is to be noted, Your Lordship, the guilty mind. From the very condition that no harm comes to Anita, clearly state that Akash intended to marry Anita, not to harm her. So that negates the charge of mens rea, presence of mens rea in this particular case. Your Lordship, there was no intent for
Mr. Consul, your relationship with the victim was your teacher?
Indeed, Your Lordship.
Yes, then. Yes. Wise relationship, teacher and taught. How can you defend?
Your Lordship, still, Akash was the teacher of Anita. He
Yes.
actually helped her in her studies as well. They both developed a bond of friendship.
How a teacher and student can be your friend?
Lordship, it differs fact to fact. It clearly states that Anita
Point out the relevant facts.
Lordship, gifts are given to Anita. The particular birthday party was also thrown on Anita's birthday by Akash.
Even a father is also throwing a party for his son or daughter.
Lordship, Anita attended the party as well as accepted the gifts. And after even Your Lordship, if he had no such interest or had burden, she would have stated no, clearly no, that I don't want to marry you. I perceive you as a teacher and so on and so forth, whatever she deemed fit. But Your Lordship, the no condition was not particularly made. She just stated, talk to my parents. The intention was not clearly mentioned, Your Lordship. May I proceed further, Your Lordship?
Yes.
Much obliged, Your Lordship. Your Lordship, the chain of circumstantial evidence is fatally fractured. The Lordship, there is no direct evidence of stalking intent. No proof shows that Akash came to harass Anita. Further, Your Lordship, there is ambiguity in abduction evidence as well. testimony fails to link Akash to abduction. No removal occurred. There was no removal from the lawful custody as well, Your Lordship. Further, Your Lordship, there is reasonable doubt from the conduct. Flight as innocence. Your Lordship, if someone flies away from a particular place of incident, he would not head directly to his home. It is to be noted, Akash directly went to his home. When we go to our homes, when we panic, we normally go to our homes. If Akash wanted to flee, he would have left for somewhere else, not home, because he would not wait for police to come in directly at his home and arrest that particular person. Further, Your Lordship, his no harm conditions cast doubt that there was no violent intent. Further, Your Lordship, his peaceful character strengthens this doubt. Your Lordship, a person who is a teacher, who is helping a poor girl in her studies as well, may we infer that he won't have a malicious intent. It is to be noted, Your Lordship, there is no previous.
Even his intent was not pious.
It can be inferred from the fact itself, Your Lordship. They, over the period of time, developed some kind of bond, and they were having a cordial relationship as well. Indeed, maybe it can be said that Akash did not have even a pious intent as well. But Your Lordship, he approached directly Anita's parents as well, talked with Anita also. He never forced Anita. It is to be noted, Anita never felt unsafe around Akash particularly, Your Lordship. Further, Your Lordship, there is sporadic content not constituted stalking. Akash's contacts were not persistent harassment. In the case of D. Rajiv Verma versus State of Telangana, the court noted that reasonable conduct may not amount to stalking. His messages lacked the frequency of stalking, Your Lordship. They were driven by hope to get married, not harassment, Your Lordship.
Kindly read para 2 of this statement of facts. Then reply.
Lordship, the para 2 states that Akash, a science teacher, helping Anita with her study.
You're reading para 1, para 2. Believing Anita's avoidance was due to parents' pressure, Akash contacted her through visits to her tuition classes, phone calls, online messages, driven by emotional distress, not intent to harass. Next, Anita reaffirmed her parents' stance. This is page 8. Page 8. Para 2, Roman 2.
Your Lordship, we were told not to change with the material facts of the case. That's why we have mentioned particularly in this proposition as per the fact. Further, Your Lordship, it is also been mentioned that devastated who physically rebuked him. After Anita told her parents, they physically assaulted Akash and dismissed his genuine intentions to marry her. Further, Your Lordship, it can be inferred that Anita was under coercion from her parents. From that, Akash perceived that if I talk with Anita particularly as a major person, then he can get married because the consent of parents is not required. The consent is required from the spouse only, Your Lordship. Your Lordship. Your Lordship, proceeding further with the prior permission.
Yes, please.
Much obliged. With the prior permission, may I proceed to issue number 4, Your Lordship? Much obliged, Your Lordship. Your Lordship, issue number 4 before this honorable court is that did Akash's actions constitute a conspiracy with Suresh under section 3 subsection 5 of BNS? The lines have been made, Your Lordship, for firstly 4.1. There is non-violent agreements indicates a conspiratorial intent. Your Lordship, section 3 subsection 5 requires a sheer criminal intent. Akash's agreement was for non-violent dialogue, precluding conspiracy. In case of Teher Singh versus Teher Singh case, the commentary was made. The gist of conspiracy lies in the forming of the scheme or agreement. It is to be noted, Your Lordship, the scheme was particularly to get married, not to actually acid attack her. It can be inferred that their agreement was for the non-violent non-violent talking only, dialogue only, not the commission of a violent act. Further, Your Lordship, Akash sought reconciliation, not crime, as in case Gopal Krishan versus State of Himachal Pradesh. It holded that the prosecution must prove common intention evidence as well. Your Lordship, his motive was love, not malice. His goal was dialogue, not destruction. And Your Lordship, his distress negates a conspiratorial mindset. Further, Your Lordship, he never had any previous violent character. Your Lordship, there is no particular complaint against Akash by any of his students. Further, Your Lordship, Suresh's unilateral actions and severe sheer intent. Your Lordship, Suresh acted alone. Suresh's independent acts therefore negates conspiracy. I would like to refer the case of Suresh versus State of Uttar Pradesh. It was held that Section 34 does not apply without common intention.
Kindly see para number 7 of the preposition. Read out. Para number 7. Read out.
In case she would offer any resistance due to parental pressure,
थोड़ा पीछे लो, mic.
in case she would offer any resistance due to parental pressure, Suresh will threaten her with a bottle of acid to pressurize her to come with them to the temple. Akash, who was initially unwilling, agreed to the plan on the condition that no harm will be caused to Anita, and bottle of acid will only be used as a tool to threaten her for compliance to their wishes.
क्या बोलते हो इस बारे में? Neither they neither you argued upon this point. This is the basic point. What was their agreement? आकाश और सुरेश का एग्रीमेंट ये था कि भैया मैं मान लेता हूं तुम इस एसिड को यूज नहीं करोगे, तो कॉमन इंटेंशन कैसे हुई? that was the only independent act of the Suresh. पैरा नंबर 7 में these all are evidence. जो आप पढ़ रहे हो एविडेंस है ओनली. तो यहाँ कहाँ है वो? Akash, who was initially unwilling, agreed to the plan on the condition that no harm will be caused to Anita and bottle of acid will only be used as a tool to threat her for compliance to their wishes. तो यहाँ पर कहाँ आया एसिड? क्या उसने इस चीज को तो आप ले नहीं रहे हो?
In detail Lordship, we have dealt with it that there was a precondition that no harm will be caused and the acid bottle will be used as per the facts only. We have dealt with that particular that no harm condition was particularly made. So the common intention was missing.
ये तो आपने बोला ही नहीं, किसी ने नहीं बोला अभी तक.
Your Lordship, I just dealt with it in the issue number 2 as well.
You get ready upon this point.
Sure, Your Lordship.
हाँ जी.
Your Lordship, as I just mentioned, non-violent agreement negates a conspiratorial plan. Your Lordship, I particularly stated that no harm condition was there. When I referred the case of Teher Singh also. So, Your Lordship, no harm condition was dealt in this particular case.
Okay, good. That's good. You have done a lot.
Further moving the Lordship, shocked reaction disproves conspiratorial intent.
थोड़ा पीछे रहो बेटा, माइक सुना नहीं दे रहा, हम क्या बोल रहे हो? Make a distance. Yes. नहीं, ऊपर रखो, थोड़ा पीछे रहो. ये बड़े हाई सेंसिटिव माइक से.
The Lordship, Akash's horrified flight shatters the prosecution's claim. I would like to refer the case of Rajiv Ranjan versus Central Bureau of Investigation. It states that the conspiracy requires the meeting of minds. Akash's reaction proved no such meeting ever occurred. The Lordship, his flight was a recoil from violence. A conspirator does not flee in shock. His reaction is proof of his innocence, Your Lordship. Your Lordship, his actions were emotional, not conspiratorial. His heart had hope that Anita will marry her, not to harm Anita, Your Lordship. Your Lordship, his distress negates a criminal intent or criminal agreement. Further, Your Lordship, I would like to refer another case of Hanuman versus State of Madhya Pradesh. Your Lordship, this case deals with chain of circumstantial evidence, which is greatly broken in this particular case. Your Lordship, circumstantial evidence must exclude all other hypotheses. The prosecution's chain is fractured and unable to support the conspiracy.
कौन सी chain break हुई यहाँ? What chain?
Your Lordship, the common intent which was relied on.
That is not the chain. I had earlier told you that circumstances is different and the circumstantial evidence is something different. कौन सी चेन ब्रेक हुई यहाँ पे? एसिड भी डाल दिया, ड्रैग भी कर दिया, सब कुछ कर दिया, क्या रह गया?
Your Lordship, fingerprints of Akash on the acid water. Further, Your Lordship, the absconding Suresh, his statement was not recorded. But
That's no use. When Anita is saying yes, Suresh was also with her, with him. There is no need of circumstantial evidence. There is direct evidence.
further, Your Lordship, there is no particular mention that it was Akash who actually brought the acid as well. That link is also missing in this particular.
Hypothetical analysis cannot be done. Para number 7 says that bottle was in his hand.
Your Lordship, the plan was made by Suresh only. He actually gave the idea to Akash.
Yes, of course, when the idea is transferred and he had accepted that is common intention.
Your Lordship, it is to be noted, Akash only accepted that it will be used as no harm to be done. He would have taken any other liquid as well.
If anything is agreemented between us and one person accedes to that, then
The Lordship, common intention matter in that particular case.
हमने कहा कि ड्राइंग इसको बस बंदूक दिखानी है, सर ने मुझे कहा ठीक है इस तरह की रहना, लेकिन मैंने गोली मार दी. Then
The Lordship, common intention is to be taken into consideration. What was the common intention? If the common intention was to actually, like as this is stated in the postmaster case, which was to commit the
डराने तक का भी रोल 124 सेक्शन 124 क्लॉज 1 क्या कहता है? Even threatening or acid attack, that is also liable. तभी तो शुरू में पढ़ाया था हमने आपको वो सेक्शन. आकाश ने इतना तो बोला था ना कि बस उसको डराने के लिए दिखाना है, आपने एसिड बाकी नहीं करना कुछ नहीं. That was consented. Even threatening 124 ए क्या कहता है? फर्स्ट क्लॉज क्या कहता है?
even the attempt or threatening.
बस, that's all.
But Your Lordship, it's to be taken into consideration that the plan was made. But Your Lordship, it was up to Suresh. He could have brought another liquid as well. But his intent was.
Even अगर उस एसिड पानी दिखा के भी एसिड शो किया, चाहे बोतल में पानी ही है, I am saying it is acid, it is poison, and you are threatened. Then
Your Lordship, then the criminal liability may be reduced.
कितनी सजा चाहिए आपको?
The Lordship, we are particularly denying that because the conspirator was not Akash.
Here the punishment is life imprisonment. I think so.
Indeed, Your Lordship.
124 पार्ट 2 में लाइफ है. 10 साल की दी थी हाई कोर्ट ने, नीचे लोअर सेशंस कोर्ट ने, ठीक है, उन्होंने माफ कर दी. तो कितनी चाहिए अब? आपने को मे बी रिड्यूस्ड.
The Lordship, it was a general question that if that particular intention was not for the person, then I answered to that only. We are not in this particular case aiming for the reduction in the punishment. That will be done by the learned court only. But we are denying the fact that Akash was actually aware of the fact that Suresh will eventually throw the acid on the person of Miss Anita. There was no harm condition as well. So there was no common intent to actually harm Anita. So that particular case, we are relying on your Lordship.
Yes, you have done good. अब भाई ये तो छूटने वाला है, आप बोलिए क्या बोलते हो?
Your Lordship, if you permit, may we proceed with the prayer?
Yes, prayer. Yes.
प्रेयर दोनों इकट्ठे कर लो जरा ऊंची आवाज में.
Your Lordship, thus in the radiance of the facts, summary of issues raised, arguments advanced, and authorities cited, the counsel for the respondent respectfully placed before this honorable court that it may be graciously pleased to dismiss the appeal by the state and affirm the judgment and order of acquittal passed by the honorable High Court in this regard. Your Lordship, for the court that respondent did not share common intention with co-accused Suresh to cause grievous hurt to the use of acid on Anita. Further, Your Lordship, the court may be pleased to declare that the ingredients of section 124, 78, and 87 of Bharati Nyaya Samhita are not satisfied in the present case. Further, Your Lordship, the court may also be pleased to pass any such order, decree, or judgment as the Honorable Court may deem fit in the interest of justice, equity, good conscience, and all of which is humbly submitted before this Honorable Court.
What other fit? You said that any fit. क्या शब्द बोले आपने अभी लास्ट में?
As the Honorable Court may deem fit in the
क्या
interest of
क्या इससे ज्यादा और क्या दे सकते हैं? क्या चाहिए अगर?
Lordship.
आपने कहा ये will acquit it. इससे ज्यादा और क्या मांग दिल चाहते हैं कोर्ट से बताइए? Give us the mind.
The Lordship, the particular motive of the criminal proceedings is to deal with the justice also. We want whatever the court specifies. Because the court also has the power to
हम
grant.
आपसे सिर्फ एक सवाल कर रहे हैं लैंड काउंसिल कि आपने एक्विटल मांग ली, अपील डिसमिसल मांग लिया, एक्विट करने का भी बोल दिया, अब इससे ज्यादा और क्या देगा कोर्ट आपको? अब आपको क्या वहां पे गैलेंट्री अवार्ड दिया जाएगा? नो ना, तो प्रेयर वही रखनी है जो जरूरत हो. दे कैन से कि सर एक्सेप्ट भी करो, कंपनसेशन भी दो. 2 लाख भी कम है, उसका खर्चा और करना पड़े, उसको 10 लाख लग गया, दैट कैन बी. तो ये साइक्लो स्टाइल नहीं होते काम.
Because there is a provision in section 124 of the DNS that compensation can be awarded.
Indeed, Your Lordship, even in the case of Lakshmi versus Union of India.
आपको नहीं मिलेगा कंपनसेशन.
No, Your Lordship.
Do that
before the case.
To Anita.
Yes. But Your Lordship, due to Suresh, Akash's reputation also got harmed. If he was not involved,
that is something different. वो आप सिविल केस करिए, सिविल केस करो.
Your argument should be that with the judgment passed by the High Court in your favor, the presumption which was initially in your favor, that has become double. That should not be tinkered with by dismissing the appeal, because the accused is presumed to be innocent. Although the Court of Sessions convicted you, but your appeal has been accepted by the High Court by acquitting you. Once the acquittal order is in your favor, the initial presumption now become double. Yes, within 2 minutes, not more than that. Yes.
माइक ऑन कर दो.
Lordship, everything is not fair in love and God, Your Lordship. Unrequited love. He loved her. He was so much in love that he thought that even if she was saying no, she still meant yes.
But I think you can't deny in para 3 of the statement of facts, it's specifically been mentioned. Suggested the use of an acid bottle as a threat if she resisted, assuring no harm would occur. This was his intention. Yes. Yes.
The Lordship, in the case of Shivani Karthik versus State of UP and others, the Honorable Supreme Court held that stipulations like no harm cannot be considered. They are completely irrelevant. Where the accused knowingly engages in inherently dangerous inherently dangerous conduct. Your Lordship, therefore, no harm, conditional agreement. Your Lordship, irrelevant. When you're dealing with such a dangerous object, you cannot put conditions on it that I won't use it, you won't use it, let's not use it.
What would your take with regard to the fact that with the judgment of acquittal in his favor, the presumption which was initially in favor of the accused, that becomes double? How the same can be snatched by this court at this stage? Because the High Court has also appreciated the facts.
Lordship, can you please read the I don't get it.
The presumption of innocence is there initially in favor of the accused. Accused is always presumed to be innocent unless or until proven guilty. Accused has been proved to be guilty by the Court of Sessions. However, on appeal is like hearing of the case. An order of acquittal is in his favor. How that presumption can be snatched from him?
The presumption is double now.
It has become double.
एक तो पहले लॉ की presumption है कि he is innocent until and not found guilty. दूसरे हाई कोर्ट ने मोहर लगा दी.
Now,
अब
Lordship, when my learned counsel said that Akash didn't threw the acid bottle, Akash didn't have the acid bottle. your lordship, it is to be considered he was not carrying a bucket of
ये तो
acid.
बात ही नहीं है. It is clear. He was not carrying. Neither he has thrown.
Yes, your lordship. And
Neither he has consented to give this attack. तीन चीजें तो क्लियर है.
Your lordship, ये भी clear है.
चौथा उसने ये भी वार्निंग की थी कि मेरी शी इज माई बिलव्ड, आप इतना ही करोगे, डराओगे सिर्फ, यूज नहीं करोगे. इस कंसेंट के, इस कंडीशन के ऊपर कंसेंट दी थी.
Your lordship, दो चीजें हैं यहाँ पे, if I may speak in English.
Yes, yes, please.
दो चीजें हैं यहाँ पे, acid as a means, दूसरी abducting और kidnapping the woman for to compel her to get married. तो lordship यहाँ दोनों ही चीजें गलत है. अगर हम मान रहे हैं कि उसने एसिड के लिए कहा कि टूल है, कि एसिड सिर्फ हम एज थ्रेट यूज करेंगे, ओके, एसिड एज थ्रेट यूज करेंगे, ऑल्दो शिवानी के आगे कुछ और कहना है, लेकिन आप किस चीज के लिए वो यूज कर रहे हो? आप एक लेडी को, जब वो एक कंसेंटिंग एडल्ट है, she can say when she can say she doesn't want to get married. ये लॉजिक आप अज्यूम नहीं कर सकते कि वो आपसे बेबी शादी करना चाहती है या नहीं.
भाई करना चाहती होती तो चुप, इतना पंगा क्यों था? फिर तो गाड़ी में बिठा के हार और डाल के आ जाते हम. लड़ाई तो वहां पैदा हुई जब वो कंसेंट नहीं दे रही है. देन दे हैड मेड अ मेथड. अगर वो कंसेंट नहीं देगी तो हम ये यूज करेंगे, एंड दे हैड यूज्ड इट. लड़ाई तो वहां शुरू हुई.
Even when they dragged her, she shouted in protest. It means she said no.
ठीक है, एबडक्शन में कर देते हैं कन्विक्शन, बाकी 124 छोड़ देते हैं.
Sir, acid attack में भी तो है. Acid.
हाँ हाँ. लास्ट.
Your Lordship, if arguments and the mind of the courts can, if they went through the emotions, so an emotion of a person.
क्या बोल रहे हैं आप? दोबारा बोलो.
If the mind of the court will be going through the emotions and they will be regulated by human emotions, then a person standing on street can claim that I have not raped the person because my emotion is lust, again of human emotions. Your Lordship, love, emotions and all, court cannot go like this.
तभी तो हम कर नहीं रहे.
Your Lordship, but in this
प्यार में अगर इतना सा कर लिया किसी ने तो क्या गुनाह कर दिया भाई?
Your Lordship,
एक मिनट.
for that I am mentioning that any other person standing on the street.
Courts are not run by emotions.
Yes, Your Lordship, that.
ठीक है ना? हम सिर्फ लॉ के अनुसार ही सोच रहे हैं, समझ रहे हैं, because you are the learners, you have to listen it, and in the last जो आप शुरू कर रहे हो बेटा, that is good. You try your best. It is the luck of the accused or the state. ठीक है ना? टेंशन नहीं लेने की.
But Your Lordship,
अपनी बात जरूर रखो, लेकिन तरीके से प्यार से रखनी है, आगे आपने बढ़ना है. यू आर डन वेरी नाइस. बहुत अच्छा किया आप लोगों ने. जितनी शायद अगर रेगुलर कोर्स में भी अगर हमारे से भी ऑनरेबल कोर्ट पूछते तो हम इतना जवाब ना दे पाते एट द मोमेंट. ठीक है ना? यू आर डन. आपका कैरियर अच्छा है सबका. दैट्स गुड. एनीथिंग मोर सर? तो
Now, very humble request to Sharma ji to say something.
Thank you very much, sir.
Please.
प्लीज.
thank you.
It's a pleasure to be